Hello, this is the Introduction to Criminal Justice, Chapter 11 recorded lecture. Chapter 11 is entitled Probation, Parole and Reentry. So, community corrections. This is defined as the use of a variety of officially ordered program-based sanctions that permit convicted offenders to remain in the community under some type of supervision. This includes, community corrections includes probation, parole, home confinement, remote location monitoring of offenders, and things of that nature. Essentially, community corrections involves any type of supervision of an individual out in the community as opposed to them being incarcerated after having been found involved or guilty of an offense. So at the start of 2021, about 1 in 66 adults in the United States were under some type of community supervision. So what is probation? I'm sure the majority of you have a good understanding of what it is just from the media and, maybe friends that you may know that have gotten into some type of situation at some point. But probation is a court-ordered sentence of imprisonment that is suspended and served while under supervision in the community. Now, that is your textbook definition. I would argue that probation is a sanction in which the offender is not sentenced to imprisonment, but rather sentenced to complete a period of supervision in the community. And if they do so successfully, then they can avoid incarceration. But what your textbook is saying is essentially the same thing, it's just worded a little bit differently. So offenders are sentenced to probation, but the understanding is if they don't comply with probation, they will be incarcerated. So I hope that makes sense. History of probation, it was considered binding over for good behavior. Essentially, there's some good things there that we can work with. You don't seem to be a significant threat to the community, so the courts are going to allow you to remain in the community. The first probation officer ever was John Augustus, and this was in the 1850s in Boston. And funny story, John Augustus actually was a boot maker. He made shoes, and he started to see people getting incarcerated for things even as early as 1850. And he thought, well, why aren't we giving these people second chances? So on a voluntary basis, he went to the court and asked the court to let him provide supervision to an individual out in the community and mentor that person. And because he thought he would be able to get that person right to the point where they wouldn't need to be incarcerated. The court actually gave him a chance. There was no such thing as probation at this time. So the court gave him a chance. He ended up having many people that he mentored / supervised in the community. And shortly after that, he earned a paid position as a probation officer. And that was the invention of probation as we know it today, a bootmaker from Boston. So his work really led to probation being widely accepted as a form of community supervision across our country. Federal government adopted probation, and every state was in line by 1925. So you can see the time difference between when John Augustus first started and when probation was adopted federally and across all states. So the extent of probation, it's the most common form of sentencing in the United States. So I'm just going to repeat that. Probation is the most common sentence given to an offender in the United States. Over half of all offenders under supervision in the United States are on probation. And just because someone commits a violent offense doesn't necessarily mean that they won't be eligible for probation, because there are certain times when they can get probation. We have 50 states, and each state is going to have a different way that they carry out probation, what it looks like, how they use it. So it can get a bit confusing. About 44% of the offenders discharged from probation in 2021 successfully met the conditions of their probation. So that tells us that 66% did not. About 15% of those were incarcerated due to a rule violation or because they committed a new offense. Here is a chart. It doesn't say what year it is, but this is offenders under correctional supervision by type. So we have 55% of offenders are on probation. We have 14% on parole. Then we have 23% in prison incarcerated and 12% in jail incarcerated. So what does probation mean? What are probation conditions? What do people have to follow when they're under probation supervision? Well, they have to agree to abide by court-mandated conditions of probation. So whatever the judge orders them to complete, that's what probation, their job is to make sure that those things get completed. Violations of these conditions that the judge orders can lead to probation revocation. Now, revoking someone's probation is just that. You are revoking, you are taking away their probation. And when you take away probation, then they typically end up incarcerated because they've messed up on this chance to not be incarcerated. So there are certain conditions that apply to all people under probation within a certain jurisdiction. And some of those things might be not to possess a firearm, not to be in a bar or consuming alcohol, not to commit a new offense, things of that nature that are general rules of supervision. But then there's also special conditions sometimes that a judge will order when they feel that the person under probation needs some type of specific guidance. So federal probation, authorized by the National Probation Act of 1925, federal probation and pretrial services officers are federal law enforcement officers, and they do have powers of arrest. Federal officials have implemented a results-based management and decision-making framework. So moving back to probation, I know we just said federal probation has arresting powers, just as every state has different ways that they carry out probation. They are, some states have arresting powers and some don't. I just met someone from New Jersey, and I think she said they're either probation or parole has arresting powers in New Jersey, but whichever one it is, the other one does not. In Pennsylvania, probation officers have arresting power, as do parole officers, and that's statewide. So getting back to this, what is parole? Parole is conditional supervised early release of inmates that are incarcerated. So probation, they may have never been incarcerated, or they may have been incarcerated leading up to their trial and then been released and put on probation. But parole, these individuals were sentenced to incarceration and they're getting out early from their sentence. Say it's a 4-year sentence and they served a year and a half or 2 years, just for argument's sake. Then they would be on parole to finish out the rest of their sentence, but in the community. So it's really a strategy of reentry into the community from prison. It differs from probation in both purpose and how it's delivered, although there are a lot of similarities. So what is parole? Parolees have been incarcerated, and it's an administrative decision by a paroling authority. So the parole board typically decides who can be paroled and who can't. It's also a correctional strategy of reentry, like we just mentioned. But going back to probation, probationers generally don't get incarcerated, and probation is an actual sentence option that's available to a judge. It's also part of a sentencing strategy. So there's 2 major parole decision-making models. We have a parole board, and then we have statutory decrees. So parole board is the state paroling authority that grants parole based on the board member's judgment and assessment of the individual. and it can be discretionary. Statutory decrees. These produce mandatory release with release dates near the completion of someone's sentence, minus time off for good behavior, and it is the most common reentry model. Currently seeing movement away from release by parole boards and the use of discretionary release. And I want you to think for a second about why we might be moving away from that discretionary release based on some things that we've covered in the course so far. What do we know that can happen when we use discretion? It can be good, sometimes it can be bad. So think about that. Medical parole. This is used for offenders who are considered low risk due to serious physical and mental health conditions. It's a form of reentry that is on the increase. So one example I could give you for medical parole would be someone who perhaps is incarcerated but has cancer and they are kind of near the end. So perhaps they might be granted medical parole so they could be released to go home. They're seen as low risk because maybe they're in treatment and they're not really a risk of safety to anyone anymore. So that would be an example of someone that would be released on medical parole. Parolees are one of the smallest correctional categories. There's a lot of reluctance to use parole due to concerns about lack of offender reformation prior to release. So, are they going to change when they get out if they haven't served their full sentence? About 25% of inmates released from prison are paroled. That means probably the 75%, the rest of them finish out their sentence in jail or prison. Other inmates may also serve a short period on reentry parole, and that is a form of supervised mandatory release. Slightly more than half of the offenders on parole complete it successfully, but about 15% return to prison for parole violations. So parole violation is an act or a failure to act by a parolee that does not conform to the conditions of parole. So essentially they're not following the rules that they've been given. And that parole violation can result in them being returned to prison. Conditions of parole. They are very similar to the conditions of probation, and parole can be revoked. The administrative action of removing a person from parole in response to violations of conditions. Restitution, we covered what restitution was in the last chapter, but the court requirement that a convicted offender pay money or provide services of some sort to the victim is frequently included as a condition of parole, as well as probation. Federal parole. These are decisions made by the U.S. Parole Commission. In 1984, we had the Comprehensive Crime Control Act that mandated federal fixed sentencing, abolishing most federal parole. Parole decisions are still made for federal inmates whose sentences were imposed before the Act's deadline. And here is a pie chart of federal post-conviction supervision by type. So, supervised release, 85%, probation, 14%, parole is only 1%. Here is some case law on probation, parole, Griffin versus Wisconsin, and Pennsylvania Board of Probation and Parole versus Scott. So you can check those out. Revocation hearing, we talked about parole revocation, probation revocation. In order for your parole or probation to be revoked or taken back, you have to have a hearing. It has to happen before a judge. So it's a hearing held before a legally constituted hearing body, which is typically a judge, to determine whether a parolee or probationer has violated the conditions and requirements of parole or probation. Now, I said it's typically a judge, but sometimes it could be a hearing master also. Different states and probably even different counties could handle that differently. About 16% of adults on parole have their conditional release revoked each year. So why does parole get revoked or probation? For people failing to report when they're required to see their officer, failure to participate in any kind of required treatment program, and that's most commonly like drug and alcohol treatment or mental health counseling. Or the last one, drug or alcohol abuse while under supervision. One of the general rules of both probation and parole is also submit to random drug testing. So if you're using substances during supervision, they're going to find out. Non-revocable parole, that parole that cannot be taken back. It's designed to reduce state prison populations, and offenders on this type of parole cannot be returned to prison. Potential liability of probation officers and parole boards for criminal actions of offenders they supervise or whom they have released is a key legal issue. So if a parole board, in conjunction with probation, decide to release someone early from incarceration and that individual commits a new offense and harms someone, is there liability there for the authorities that release that individual? That's what that point's talking about. Most experts agree that parole board members cannot be successfully sued unless release decisions were made in a negligent or reckless manner. Discretionary decisions by individual probation or parole officers that result in harm to the public could be more actionable. Here are some more case law, U.S. Supreme Court decisions for probation and parole. You can check these out. I'm sure there is a chart in your textbook also. Here's some more. So the job of probation and parole officers, 4 main functions. Complete those pre-sentence investigations that we talked about last chapter, PSIs, intake procedures, diagnose and needs assessment, completing a risk assessment on the individuals, and then the most important piece is supervising the offenders out in the community. There is a strong emphasis of confidentiality, but officer-client communications are not privileged, which means whatever a client says to a probation officer is not confidential. It can be presented to the court and used against them if whatever said was egregious. A lot of challenges to the job. There's really, like, probation officers wear many hats, but there are 2 main ones, and one is that of a social worker, essentially trying to help the offender get back on their feet, get them enrolled in counseling, helping them get a job, helping them get work, all those things. And on the other hand, you have to be prepared to take an individual into custody if they're not following the rules and doing what they need to do and posing a risk to the community. So you have that social work aspect, and then you have the law enforcement aspect. So you have to be able to switch between the two. In the field now is very heavy on the social work side, and it's very treatment oriented. Officers typically have large caseloads. That means they have a lot of offenders that they're supervising out in the community, and so that can be very stressful. There's also, your book talks about lack of career mobility within the profession. Like, where do you go? Like, do you just get stuck in probation? And I would argue that that's not accurate. I've seen many people come into probation and leave to go into some other type of work. I myself am a probation officer, although supervisor. I also teach at RAC and also at Penn State Berks. So I would argue that there is definitely opportunity for you to change careers within criminal justice, that you're not pigeonholed into probation once you start there. And I mentioned already high stress levels. You're dealing with sometimes a lot of nonsense that you have to filter through. And you're trying to figure out how you can best work with an individual and best help them. And so sometimes that can be very taxing on you. Switching into intermediate sanctions. These are sentencing alternatives that fall between imprisonment and probationary release. So they're less expensive than putting people in jail or in prison. They are socially cost effective. And so what the heck does that mean? So if something is considered socially cost effective, that means like as a society, it benefits us more. So when we lock people up and incarcerate them, eventually they're going to come back to the community. 9 times out of 10, they're coming back to the community. But what we've done then is remove that individual from everything they know during the period of incarceration, which is sometimes necessary. But then when they come back into the community, they may not have a good understanding of how things are now. Like say you got arrested and you were incarcerated 20 years ago and you get out tomorrow. We didn't have cell phones like we have now. There was no AI. Just all the technology pieces that an individual may not be familiar with upon stepping out of prison. So the ability to keep an offender in the community and work with them and treat with them in their home environment can be much more socially cost effective for everyone as a community than incarcerating them. There's also a lot of flexibility with intermediate sanctions. We have split sentencing. This is a sentence requiring the offender to serve a period of time incarcerated followed by a period of probation. Typically 90 days in jail followed by 2 years of probation. And this is typically used for minor drug offenders. Shock probation and shock parole. This is where an offender would serve a short period of time in custody and then they're released to probation. Clients have to apply for probationary release, and then the court makes a resentencing decision. Shock parole, similar to shock probation, but it is an administrative decision made by the paroling authority. I myself have never, aside from the textbooks and the courses I teach, I have never come into contact with shock probation, shock parole, or even heard of it outside of the courses I teach. Shock incarceration. This is a sentencing option that makes use of a boot camp type prison settings. It was really popular during the 1990s. If you remember, or not remember because maybe you weren't around at the time, there were, they called them scared straight programs, where they would take a kid who was being bad at home, not listening to his parents or mouthing off or disrespectful. They would take that youth or a group of youth and take them to a prison where they had inmates set up that would scream in their face and try to show them how awful it is in jail and try to scare them. That actually ended up going terribly sideways. Not only was it not effective in helping those youth, it actually introduced them to more criminal behaviors and criminal mentality and overexposed them to that, which actually made them a little bit worse than they were when they went in. So we no longer use boot camps. If you hear that term, now you can explain why places don't use boot camps anymore. Mixed sentencing and community service. So mixed sentencing is a sentence that requires a convicted offender serve weekends in a confinement facility like a jail and receive probation supervision during the week. Community service, a sentencing alternative that requires offenders to spend at least part of their time working for a community agency like a church or a nonprofit. There's really not a good understanding as to what exactly community service is accomplishing, aside from, them doing work for free. There's not a lot of research that backs up that community service sentences are effective in any way. Intensive supervision. So you have individuals on probation or parole, and then you have individuals on intensive supervision. So it's just like it says, just like the word, it's a form of probation involving more frequent face-to-face contact between the offender and the probation or parole officer. So if you're an adult on probation in Berks County, you might see your probation officer once a month. If you're on intensive supervision, you might see your probation officer once a week. You might even see them 2 or 3 times a week. So that's the difference between regular probation and intensive. It's the strictest form of adult probation in the United States, and research suggests that these intensive supervision programs can be effective at reducing recidivism. Recidivism meaning the individual committing a new offense and getting rearrested, because that is what we are trying to avoid. Home confinement and remote location monitoring. This is essentially house arrest. Offenders are confined to their residences wherever they live, and we use remote location monitoring to track them, such as an electronic monitor on their ankle. It's a good alternative for offenders that have special needs that we don't want to put in prison, or as an alternative to putting someone in prison. We can try this first. So there's different levels of federal home confinement. We have curfew. So federal probation might give their clients curfews they have to be home by. They might place them on home detention, and they might give them home incarceration. So home detention might be you're not allowed to leave your house except for when I let you, or home incarceration might be you're in your house, you're not allowed to leave at all. And interestingly, these can be done with or without electronic equipment. When electronic equipment is not used for home confinement, typically you'll have the probation officer stopping by at least once a day to check in on the individual, make sure they're there. But when electronic equipment is used, let me move this out of the way. Go. Here is a graphic on how the system works. Now this is older systems use satellite signals. We use GPS now, Global Positioning Service. Yeah. All right. The future of probation and parole. Parole was widely criticized in the 80s and 90s. Groups claim that parole unfairly reduces prison sentences that are imposed on offenders. Essentially, they wanted them to serve their full term. Probation was faulted for being seen as a relative lack of punishment. Some people see probation as a slap on the wrist. That's not a big deal, and that's not fair, that they didn't get punished enough. Academics allege probation and parole cannot ensure offenders will not commit future crimes. Sure, we can't ensure that anyone's not going to commit an offense in the future, but we can give them a try. There's concerns about the inability of parole to curb recidivism. Again, same thing. We can try to prevent it, but it's not always going to happen. There are going to be offenders that re-offend. Parole violators account for over half of prison admissions in many states. So is that something that we need to look at? Critics argue high recidivism and failure on parole indicate poor reintegration of incarcerated people into the community. So what that's saying is that critics are saying that when we're releasing people from prison, we're not doing enough work to help them get back into the community and get on their feet, because their success rate is low. Some incarcerated people have challenged the fairness of parole. Is it arbitrarily granted through those parole boards? The unpredictable nature of parole experience also depending on where you live, who your parole officer is. So here is the annual arrest percentage of prisoners released over a period of 9 years. And you can see within the first year they're most likely to get rearrested, but as we move through, they're less likely. Changes in reentry policies. Almost 2 out of every 3 people released from prison are rearrested within 3 years of their release. So those issues to reentry, like we just spoke about, 3/4 of those released from incarceration have some history of substance abuse. So while they were incarcerated, they couldn't use, but when they come out, that's right back in their face again. 2/3 have no high school diploma. That poses a risk for them to get a job. If you don't have an education, it can be very difficult to get a job, or at least one that pays decent. Over a third have physical or mental disability. There's a high rate of serious mental illnesses, and that adjustment to leaving prison and coming back into the community can be overwhelming for some, especially with a mental illness. Serious violent offender reentry. So this is geared towards serious and violent offenders. The goal was to reduce the likelihood of reincarceration by providing tailored supervision and services to improve the odds for a successful transition back into the community. It included a 3-phase service continuum, but funding ended in 2012. The evaluation found some good results for men, and not as positive for women. We also have reentry courts. We don't have any of those in Berks County, but we do have reentry courts. They are specialized courts that combine intensive judicial oversight and rehabilitative services. It's based on the drug court model, or treatment court as we call it here in Berks County. Reentry court judges oversee the offender's supervised release into the community, and they offer an array of reintegration services which they can connect offenders with. There's also the Second Chance Act of 2008. This authorized $400 million in federal funds to assist offenders re-entering the community. The act created the National Reentry Resource Center and funded prison to community transition services and programs. Although the research on reentry courts didn't really show a significant impact on recidivism. The First Step Act of 2018 was also a change. In addition to the implementation of risk or needs assessments. So these are social scientific techniques used to determine the likely risk of recidivism and appropriate type of risk reduction efforts. All right, that's a lot of words. A risk needs assessment is something that we covered last chapter briefly, but it's assessment that's conducted by probation and parole typically after interviewing or meeting with a client, and it tells us their risk to get in trouble again and what areas of risk are most high for that individual. And there's typically different domains: family circumstances, education, employment, peer relations, like who they're hanging out with, where they live, what kind of environment that is, substance abuse, mental health. This assessment is also going to look at prior criminal history. So it's going to identify areas of concern that the office needs to focus on, the probation officer, but it's also going to look at some strengths. So what is this individual really good at? And how can we focus on those strengths to build up that person to reduce those areas of risk? So these risk needs assessments are evidence-based tools that are validated to be scientifically effective. And when we work with youth and we utilize those risks and needs and strengths, we can be much more effective at how we're working with that individual. So here is a flow chart of how the prison reform works in the First Step Act. This is probably in your textbook also. So here we are with evidence-based practices. I just gave you a little nugget 2 slides ago. The primary purpose of probation has always been rehabilitation, rehabilitating offenders so that we give them the tools and we help them, we teach them how to work through situations. We try to create positive thinking patterns so that when they come out of probation or incarceration, they are better equipped to handle situations than they were when they got in. And so that if they were in the same situation they were previously, that they would make a different decision, hopefully. Reentry advocates today focus on risk prediction tools to assess likelihood of the offender being successful in order to consider them for community supervision. Treatment-oriented, intense supervision of offenders in the community is said to have the largest impact on preventing them from getting in trouble again. And evidence-based practices are firmly established in probation and parole. That's all.